gun sales increased in Illinois in the past year, one of only 4 states to do so.
Downstate federal judge has just thrown out Illinois' latest gun ban. The judge.
Fight is not over.
Without having to go through the 4473 form.
Right now, a bill is advancing through the Illinois General Assembly with a financial burden so enormous it could by itself eliminate every gun maker, every shop owner, and every distributor working within the state. And the most troubling part, the vast majority of Illinois residents haven't the faintest clue it's on the way. Let's discuss what's going on in Illinois, because what's developing in Springfield at this moment is unlike anything we've witnessed in the contemporary era of weapons policy. While nearly every other state has concluded its legislative sessions, and gun owners in those regions already understand the harm that's been inflicted, Illinois remains wide open. The General Assembly is still convened, legislation continues advancing, and the cutoff dates meant to control how those measures progress are, well, let's just say they function more like friendly advice than binding requirements. Here's what you must grasp about how the Illinois General Assembly functions. There's a procedural checkpoint called the third reading cutoff. Elsewhere, lawmakers refer to it as the Chamber of Origin deadline. The idea is straightforward. If legislation originates in the House, it must clear the House by this date so it can transfer to the Senate and ultimately reach the governor. The reverse holds true for Senate bills in Illinois. That cutoff was established for April 17th. Seems solid, doesn't it? Seems like there's an inherent safeguard against 11th hour legislative mayhem. Except there isn't. The controlling party in Illinois can vote to waive the regulations whenever it chooses and accomplish virtually anything it desires. If you want evidence, simply observe how rapidly broad weapons policies have been forced through previously. So, although April 17th appears to be an immovable barrier on the schedule, in reality, it's scarcely more than a caution sign, and that carries huge significance when you examine the timeline of the measures we're about to examine, because multiple bills aren't even slated to leave committee until April 24th. A complete 7 days beyond that alleged cutoff. That ought to reveal to you precisely how much regard the Assembly holds for its own procedural guidelines. So let's dive in. Let's dissect the measures that every gun owner in Illinois must be monitoring at this moment, beginning with the single most impactful piece of weapons policy ever introduced in the state. It's known as the Rifle Act, and it comes in 2 simultaneous versions. One resides in the House, the other in the Senate. This is an approach that's growing more prevalent in states aggressively pursuing public disarmament. You submit identical legislation in both chambers at once. That way, adversaries must wage battle on 2 fronts. Even if you succeed in defeating one version, the alternative continues progressing. It multiplies the defensive resources needed and vastly improves the odds that some form of the policy endures. Now here's where matters become genuinely shocking. The initial expense framework built into the Rifle Act came with a cost of $866 million. Allow that to register for a second $866 million in oversight expenses and compliance obligations crafted to be levied on weapons producers, shop owners, and distributors conducting business in Illinois. Whispers have been spreading that this amount has been lowered in more recent drafts of the measure, but even the diminished figure supposedly stays in the hundreds of millions. That's not a minor adjustment. That's an annihilation-level catastrophe for the weapons sector within state lines. The whole purpose of an expense framework like that is to render it monetarily unfeasible for companies to function. You don't have to outlaw firearms directly if you can merely make it financially impractical to market them. The outcome is identical. The state transforms into a weapons wasteland, and law-abiding residents forfeit access to their constitutionally protected rights, not via an outright ban, but through monetary asphyxiation. The House version of this measure has attracted 48 backers. The Senate version has 26. Those aren't modest figures. Those are figures that signal authentic legislative traction. The House version has been resting in the Rules Committee since late March, but reports indicate it could be summoned to the chamber for a third reading and ultimate vote at practically any moment. The Senate version has been stationed in the Weapons Committee since early March and carries a fresh slated departure of April 24th. Both measures are displaying clear indications of vitality, and anyone who writes them off as stillborn is committing a perilous error. Now let's move to the subsequent category of legislation that's producing genuine alarm, and that's the push to prohibit an entire category of widely owned pistols. There are 3 distinct measures pursuing this objective. 2 of them sit in the Senate. 1 sits in the House. The House version has been essentially lifeless since its introduction. It still maintains only only its original sponsor entered committee and has never re-emerged. That's the pattern of a measure that nobody is genuinely advancing. It's deceased in everything but official status. But the Senate presents a contrasting picture. One of the two Senate versions has attracted 6 extra backers since its submission. The other has gained at least 1. Both are positioned in the Weapons Committee with slated departure dates of April 24th. They aren't advancing rapidly, but they aren't deceased either. There's a heartbeat. And in an assembly where regulations can be waived at any moment and cutoff dates don't genuinely signify what they state, a heartbeat is sufficient to pose a threat. Now, I want to pause to recognize something that frequently vanishes from these conversations. Not every proposal emerging from Springfield is harmful. There are assembly members who are battling on the opposite side of this matter, and they merit acknowledgement even when the arithmetic isn't working for them. 2 state senators introduced numerous proposals that would have broadened concealed carry recognition with neighboring states and reduced the qualifying age for state weapons permits. Neither of those measures stood any practical prospect of moving forward, considering the makeup of the assembly, but the attempt counts. It transmits a message, it establishes documentation, and it informs voters that somebody in the building is genuinely advocating for their concerns. So, acknowledgement where acknowledgement is warranted. There's additionally a measure addressing concealed carry rights for ex-correctional officers, constructing a system for them to preserve their qualifications after departing the field. That one has demonstrated slight advancement, but doesn't seem to be a primary focus for either faction. And then there's one more measure that absolutely warrants mention, not because it's advancing anywhere, but because of how completely it demonstrates the mindset propelling some of this policymaking. One state senator introduced a measure that would have revoked citizens of their driving privileges and their capacity to register an automobile if they forfeited their state weapons permit. Absorb that deliberately and allow it to register. Forfeit your gun permit. Forfeit your capacity to operate a vehicle. The association between those two matters was never clarified. No sensible justification was ever provided for why the cancellation of a weapons permit ought to connect to motor vehicle documentation. It's the sort of legislative proposal that appears crafted purely to penalize gun owners, to generate supplementary fallout for anyone who slips out of compliance with the state's weapons bureaucracy, irrespective of whether the root cause relates to community safety whatsoever. The encouraging news is that this specific measure appears to be heading absolutely nowhere. It's lifeless, and it merits remaining that way. So let's tie this all up. If you're residing in Illinois and you value your capacity to legally possess firearms, there are 4 particular measures you need to be observing with intense focus right now on the Rifle Act side. That's the House version and the Senate version, both bearing that sector-destroying oversight framework on the pistol prohibition side. That's the 2 Senate measures that still display signs of life in the Weapons Committee. Everything else is either deceased, fading, or too trivial to shift the balance. But those 4 measures represent a legitimate and pressing danger to the weapons environment in Illinois. And here's the element that renders all of this so maddening for the individuals experiencing it. Illinois has already endured cycle after cycle of constraints. The state's weapons statutes are already among the most oppressive nationwide. The permit system, the cooling off periods, the assault weapons policy that was driven through at lightning velocity. Each fresh session delivers another surge, another collection of proposals engineered to squeeze the vice slightly tighter. It's gradual by intention. Each separate measure can be presented as limited or sensible, but the accumulated impact across years and generations is a state where the actual capacity to practice a constitutionally protected right has been methodically eroded. What distinguishes this particular session is the magnitude of ambition. The Rifle Act isn't gradual. It isn't a minor adjustment to current regulations. It's an effort to fundamentally alter the economic landscape of the weapons sector inside the state. If something carrying that magnitude of expense becomes statute, the consequences won't be incremental. They'll be instant and devastating for enterprises and purchasers alike. And the twin measure approach guarantees that even well-coordinated resistance campaigns encounter a steep climb. The takeaway reaches past Illinois, the methods being utilized in Springfield, the paired bills, the waived cutoff dates, the enormous oversight expense frameworks engineered to accomplish prohibition through finance rather than direct bans. These are approaches that will be duplicated elsewhere. What succeeds in one assembly gets analyzed and embraced in others. The strategy manual is being drafted live, and Illinois is the proving ground. If you care about how this unfolds, whether you reside in Illinois or not, Remain aware, follow the measures, comprehend the procedures, recognize when the cutoff dates arrive, and more critically, recognize when those cutoff dates don't genuinely matter. The specifics are where the struggle is decided, and the specifics in Illinois at this moment are profoundly alarming. That's all for today, folks. See you in the next video.